She's trying to sneak out. Court does recall the case of the People versus Michael Russell.
Another Water Assistant Prosecuting Attorney to the People.
Assistant Public Defender Chelsea Vergils with and on behalf of Michael Russell, who approaches. Mr. Russell, please state your name.
Michael Russell, for the record.
Your Honor, thank you for passing this to allow me to speak with my client. I have provided the court with a preliminary exam waiver form. I believe Mr. Russell is very much aware of his right to a preliminary exam. There has been an offer by the people in circuit court that he is interested in, so we are asking to waive his preliminary exam.
Did you wish that offer stated on the record?
Yes, Your Honor.
Thank you, Your Honor. If this matter went to preliminary examination today, the people would be seeking additional charges of resisting and obstructing, causing injury, as well as potentially one other additional count of resisting and obstructing. Pursuant to Mr. Russell's waiver and to be guilty to the existing current counts 1 and 2, the people will agree not to seek additional charges. Further, the people will also agree that he may plead no contest to those existing charges 1 and 2 on the issue of potential civil liability, and the people would further agree to a sentence of probation with no prison term. Any jail term would be up to Judge Hammoud, before which Mr. Russell would be sentenced.
The courtroom falls silent as Michael Russell stands before the judge. His attorney pleads for compassion, explaining how he's caring for his father, struggling with health issues, and trying to rebuild his life. But the prosecution reminds the court of his past, the fleeing, the resistance, the injuries caused. The tension builds, and everyone waits for the judge's next words.
And a correct statement.
That is our understanding of the plea.
All right, Mr. Russell, you're going to waive your right to a preliminary examination?
Yes, Your Honor.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I understand, Your Honor.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Understood, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant's bound over to circuit court on grounds. Ms. Regent.
We acknowledge receipt of the information, waive his formal reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for
November 3rd at 1:30 with Judge Hammoud.
November 3rd, 2025, 1:30 before Judge Hammoud.
Your Honor, may I address bond?
You may.
Your Honor, we're asking for a personal bond in this case. This is the only thing holding him at this time. My client stays in Washtenaw County. He has an address with a relative he can stay with. He has a good relationship with his family, has been in communication with his mother, who is supportive of him. He also helps take care of his father, who is at a senior center in Milan. Close with his siblings as well. He's employed in construction and cleaning, has his own business. He really wants to get back to that. Of utmost concern to my client at this time are his health issues that he's suffering from. He has high blood pressure, which can be very dangerous, and is had a recent fall at the jail that severely injured his back and neck. He believes he needs to go to the hospital. He would like to seek medical treatment for that urgently outside of custody. So to be with his family, to continue work, and to seek that medical treatment, we're asking you to consider a personal bond.
Response.
Your Honor, the people would object. Facts of this case, Mr. Russell was found trespassing at a lot in Ypsilanti. Officers observed him as someone who matched the description, had been there the night before, and was believed to be stealing items. When the officer said to stop, he ran. Additional officers arrived on the scene and chased him. He hopped a fence. 2 officers hopped that same 10-foot fence, dropped down. The officers were injured. One in particular suffered scratches on his arm as a result of this. Mr. Russell still refused to stop. Eventually, he had to be tased in order to stop him, and then he was taken into custody from there without further incident. This is not the first time that he has chronicled with police. He has a history of resisting, fleeing, and eluding. He's been sent to prison for this on multiple occasions. While we have reached a resolution in this matter that does not involve prison, the people believe that he should be released after this case is ultimately resolved with the proper safeguards and guardrails in place so that he can maintain whatever his issues are and get those under control before his release.
Moments later, the judge finally speaks. Bond denied. Her voice is calm but firm. The past can't be ignored, no matter how sincere the promises. Russell lowers his head, realizing his freedom will have to wait. The courtroom's energy shifts. Justice feels heavy, but necessary.
Anything from?
Yes, Your Honor. Although he is interested in that plea deal at this time, the allegations remain allegations. This is the only thing holding him. I believe Mr. Russell would attend future court dates and fully intends on complying with any probation he's sentenced to. I would ask the court to consider release on a tether, if not just a personal bond.
Well, given the fact that they said, alleged that officers were injured, but also he does have a history of flight from authorities, the court would consider him a flight risk at this time. I'm going to deny your request. Certainly, Judge Halou can take a look at it and make a determination as to how she wishes, if the defendant's released, how he would be released in the circumstance. So, motion's denied, bond will continue. Thank you.
Thank you, Your Honor. Have a great day.
Thank you. You too, sir. Ready? It's your best hand? Of course, everything I had left is mistake. I didn't say that badly. I just said that because we have to wait and see what happens.
As the hearing ends, the lesson is clear. Every choice leaves a mark, and redemption demands proof, not words. If you want to see more real courtroom moments and powerful judge decisions like this one, make sure to subscribe to our channel and turn on the bell for the next dramatic hearing.